Good evening. This is CTV News for Tuesday, February 26th. I'm Patricia Valone. Thank you for joining us. Well, one local advocacy group delivers pork sandwiches to Maryland lawmakers today.
We would like to leave Delegate Kelly a pulled pork sandwich. Can we do that with you?
Progressive Maryland says the state suffered nearly a 4% cut in federal funds over the last 2 years, and now random sequestration cuts will further hurt Maryland residents and the economy.
We want to make sure that our lawmakers, our state level senators and delegates understand the exact impact that sequestration will have on the people of Maryland. We're delivering a pulled pork sandwich to them as sort of a tongue-in-cheek reminder that pulling pork can be satisfying, especially when it means that, that vital programs that Marylanders depend on will be preserved.
Sequestration is a very blunt instrument. For example, one of the things that it cuts is health care for military retirees and training. But on the other hand, it doesn't really address things such as the some of the outdated and inefficient and extraordinarily expensive weapon systems like the F-35.
And following the press briefing, Progressive Maryland also lobbied state senators and delegates, calling on them to pressure Congress into action. Well, the U.S. Supreme Court hears arguments today in a case that may throw a monkey wrench into the widespread use of DNA testing. Maryland joins 27 states and the federal government in enacting laws that allow automatic DNA collection from people at the time of their arrest. The question now is whether it is unconstitutional to do that without a warrant and for the sole purpose of checking the sample against a national database. The defense, a lawyer in the case, points to the intrusion of DNA sampling and says the act violates the Fourth Amendment. But University of Maryland lecturer and criminalistics consultant Thomas Moriello says the act is no different than traditional fingerprinting.
When somebody's arrested, their fingerprints are taken. Their fingerprints are a form of identification. The portion of the DNA that the police use to put in a database is for identification only. So I'm glad it's going to the Supreme Court, so there's no more issues. I hope, obviously, that they're going to agree that it does not violate the Fourth Amendment and that the police can continue to do that because it's vital to cold cases and cases where DNA has been found at a crime scene but there's no possible suspect. Cases years later are done through the proper process using the FBI CODIS database.
And the case before the U.S. Supreme Court stems from a 2009 arrest of Alonzo King, a Maryland man who was arrested for assault, but after being swabbed for DNA, was linked to a 6-year-old rape case that had gone cold. King was later tried and convicted of rape and sentenced to life in prison. The conviction was later thrown out by the Maryland State of Appeals on grounds that the DNA was not used to prove the initial assault charge. Well, Prince George's public schools were on total lockdown for a short time this morning. That's because students, faculty, and staff participated in a systematic emergency drill that was designed to test internal procedures. During that 20-minute time frame, visitors were prohibited from entering the building, and participants were not allowed to exit. Since the Sandy Hook massacre in Newtown, Connecticut, several recommendations have been made to enhance security throughout county schools. Well, the County Council votes to adopt a resolution that aims to address the growing rash of teen violence in Prince George's schools. Since the beginning of the school year, 6 students have been murdered. The legislation approved this afternoon establishes a 13-member work group on crime, children, and safer communities that will offer recommendations. But the recent problem has many wondering what they can do to help and if there are any current programs geared toward helping young people. Joining us now is Phil Lee, who heads up the Community Public Awareness Council, an initiative that not only mentors youth, but teaches them how to better deal with conflict. And thank you so much for joining us.
Thank you for having me.
And so tell us a little bit about what is the purpose of your group.
Well, the purpose of our group, and we're better known as C-PAC throughout the county, it has 3 primary objectives. The first is a diversionary program, a process to keep the children out of the criminal justice system. In doing so, we look at the second tier as being education. We know that children in school are going to be a more productive child. And the third is conflict resolution. We not only conduct conflict resolution sessions, but we teach the children how to resolve some of their conflicts in an effort, once again, to keep them out of the criminal justice system.
Which leads to my next question. What do you think is causing this spike in violence lately?
It is a very, very hard question to answer. From our staff, we look closely at what's going on, and we believe that there's a need for more parental involvement, more parental guidance, but there's also a big part for community law enforcement and educators to play. We have to do more and spend more time teaching children how to be socially productive.
And your group is holding a meeting of the minds, a mentoring session of sorts. Tell us about that.
We call it a mentoring session for lack of a different term. You cannot just ask a child to go to school. You have to find out why they would not go to school. So every Saturday we have no less than 40 children in-house, and we discuss with them the issues that they believe inhibit them from attending school, or in some cases getting into trouble. So we look at real-time issues with the children. We talk to their parents. The parents must be a part of the process. Mentoring, well, once again, we focus on teaching the children life skills. We teach them how to work with law enforcement. We teach them how to learn how to learn.
We have less than a minute, but tell us a little bit about that transition from middle school to high school. That seems to be a big point in life.
It is a big problem. Recently, well, over the last year, we've worked on a program that we now call Transition 8-9. We know that nationally, a student's most challenging academic time is transitioning from middle school to high school. We kind of use a simple analogy with little Billy, who's been a 4.0 since he's been in school, and he's done all the things his mother's asked him to do. And now he goes to the great big high school, and he sees all of the wonderful things that lead to independence in the high school, and sometimes, most times, it is overwhelming for him. So with the help of our sheriff's deputies in the middle schools and our SROs from county police in the high schools, we're going to teach little Billy what to expect when he goes to high school and what not to get involved in. We teach him that he does not want somebody to lead him what to do, so he doesn't need to get involved with a gang. He can get involved with more productive people.
And it sounds like you have a lot of opportunities also for volunteers to come to the organization.
Yes, we do. We have a lot of great volunteers, but we always have room for one more.
All right. Thank you so much, Mr. Lee. And for more information on the organization or to become involved with the group, you can log on to cpacpgc.org. Well, a 29-year-old man's trial has been postponed after a judge declared a mistrial yesterday. Jason Scott is charged with double murder in the deaths of Dolores and Ebony DeWitt. Their bodies were found in a burning car in 2009. Scott's trial was into its second week when a witness on the stand said that the defendant had been involved in multiple home invasions. However, based on the judge's ruling, the witness wasn't supposed to mention that.
It really was something that was an accident, a slip of the tongue, if you will. You know, the judge even said in making his ruling that he understood this was not done on purpose. And, you know, we understand the judge acted out of an abundance of caution, and we certainly respect the decision, and we feel that it was the right decision. But, you know, we want to make sure that everything is fair. And this will give us a chance now to kind of go back and look at how we prepare witnesses. You know, we always have a way to make sure that we improve as we go. And we don't think this will jeopardize the case in any way whatsoever.
And Scott's retrial is scheduled to begin on October 21st.